It is good enough that you made a will. Congratulations. But you desire to make certain changes to the will, and you have been wondering and wishing that you could. Yes, you could, but you have to be careful. Normally, a will does not take effect until the death of the testator. The testator is the person that makes the will. So, in actual fact, the will can be amended or altered at any point in time during the lifetime of the testator. As far as the testator remains alive, he can amend or alter his will. As I often say, the death of the testator gives life to the will. In actual fact, it is life in exchange for life. Simply put, the will is the voice through which the testator speaks from the grave. So the testator actually speaks from the grave through his will. At the time the will is being read, everyone is listening and can hear the voice of the testator. So you see, at the time of making your will, anything can happen. So you can decide to change your mind as to what you have given to A, or maybe you want to change the property that you want to give to B and all of that. You see, at this point, you can make alterations, provided you have not executed the will. What do I mean by executed? It means that you have not signed the will. So you can make any changes you want to make at that point in time. Yes, you may have written the will, but if you have not signed the will, you can alter the will and make certain changes you want to make without any further ado. You may also want to ask me, what if I have signed the will? Can the will still be altered? Can it still be amended? The answer is yes, you could. Now, in making this alteration, you must do it properly according to law. How do I mean? That is, you and your two witnesses must sign your signatures on the margin of the will, on the margin of the document, near or opposite the alteration that you have made. So what does this mean? It simply means that if you have made a will and you have signed that will and you intend to make alterations to that same will, you are required to execute that will in the manner that you have executed the first will. Let me make it simpler. You are supposed to sign the will with your witnesses present the way you did it the time you were signing it in the first place. If you have made a will, the law also allows you to be able to revoke that will that you have made. In actual fact, it is not final until the day you, the testator, pass on. So you may revoke the will by your express deliberate action or by some other means that the law has prescribed. So here is the interesting part. I would like to mention a few ways by which you could revoke your will. One, by making a subsequent will, or by making a codicil. Then the one I actually find interesting the most is by contracting a subsequent marriage. That is, if you remarry. I believe some of you might be wondering, what is he saying? Yes, if you contract a subsequent marriage, that is a new marriage, it can revoke your previous will. That is the will that you have as at that time. Here is the more reason you need to listen and pay attention. The question is, how does a subsequent will allow you to revoke your existing will? The law allows you to revoke in part or in whole your existing will through the making of another will or a codicil. And now, the most obvious way to revoke your existing will through another will is by including a revocation clause in that new will. For example, you can say, I revoke all former wills and testamentary dispositions and declare this to be my last will and testament. The next thing I'm about to say is very, very important. So please listen carefully. Now, if your subsequent will does not contain a revocation clause and you had made an earlier will, what will happen is that if any part of that your earlier will is conflicting with the new will, only that part of your earlier will which is in conflict with the new will be revoked. So, just because you have made a new will does not mean that the totality of your previous will has been revoked. You can only revoke the totality of your previous will by including that revocation clause in your new will. So you have to be careful and not make these mistakes. These are some of the things that cause commotion and arguments and court cases when somebody passes on and his estate is being distributed. Please also listen to this very carefully. If you have made a will in a foreign country and you are now making a will in your homeland, let's say Nigeria for instance, you must be careful in drafting your revocation clause so that that revocation clause does not affect your will in foreign country. Hear me, as little as this may sound, it affects a lot of people, and executors find it very difficult in distributing their estate. Actually, I know that a lot of you have been waiting to hear how a marriage can revoke your will automatically. Yes, it can. So, this is the idea. If you have contracted a new marriage and you have children in that new marriage, of course you have a spouse, a new spouse. What the law aims at achieving is that you should not disinherit your new children and your new spouse from benefiting in your estate. What happens here is that the law creates some form of intestacy. Intestacy is when somebody dies without making a will, so that the children and the spouse of the new marriage can be captured in the distribution of the estate of the deceased person. If you're opportune to watch this video and you have examined yourself and you know that you are affected, I advise that you do the needful. Capture your beneficiaries in your will. Update your will so that no one is left out, so that you do not defeat the purpose for which you had done your will in the first instance.